we did Kuna. Well, here your lordship, if your lordship so insists that your lordship kindly take up the matter to improve that lacuna, my lord, of order 41 rule 27. He has got
Order 41, have you filed in order 41 rule 27?
well, if your lordship, then
if we feel it is necessary for complete adjudication, but there are judgments that you cannot be used to fill up your lacuna. We don't feel it necessary. Why should it be necessary otherwise?
Yeah. Now, my lord, only thing is this, my lord.
Your allegation you had to prove.
No, my lord, only thing is since the marriage, my lord, since my lord 2007 till 2026, my lord, we could not live together. Since there was no love lost.
That remains.
Yes, so my lord, what is the use of my lord content? Well, kindly see the both husband and wife, my lord, they are not in a position to live together, and their life already vitalized.
We find that the respondent wife was represented by Mr. Suranjan Mundal.
Yes, my lord. Yes.
We are concluding your arguments.
No, my lord. Only
give
thing
a notice to the other side. We'll hear them and dispose of the appeal.
My lord, only thing is I can rely on certain.
You rely on.
Yes. My lord, my point is this, my lord. Apart from that, my lord, that cruelty and unable to live together, husband and wife. Well, my point is this: rightly or wrongly for any reason, since there is no love lost between them from 2007 to till 26, my lord. Crucial.
There is no love found between them. Love has been lost. There is no love at all.
And there no love lost between them. Then, so, my lord, only thing is, what is the use of continuing this marriage, my lord? Let them live separately. Let them have their place.
This is cite the judgment.
Yes, ma'am. Yes, ma'am.
There are several.
So, my lord, I'm only thing is this, my lord. My lord.
Yes. There are 22.
My lord, I am laying on, my lord. Kindly come to my lord, paragraph 11. This case has travelled from the family court to the High Court, and now finally the decision of the Delhi High Court is such a goes to
Para 20, 22 and 23.
Yes, yeah.
Para 20, 22 and 23 contain the crux.
Yes, sir. 22,
irretrievable breakdown is cruelty by the parties to each other. It has been included within the term cruelty under 13(1)(a). And
25 cruelty.
Yes.
And my lord, here my lord, only the irretrievable breakdown.
Yes.
Now, my lord, previously only the Supreme Court has that power, but
up till now it was
this is
suggestion to the Parliament.
Now your lordship can take a deal with this matter so far as irretrievable. Now,
what other judgment?
Now, my another judgment, my lord. Kindly have a look at it.
Was there any mediation or anything in this matter?
Yes, my lord, mediation failed. Your kindly have a look at the order, my lord. Your lordship was plea to direct that let them there mediation, competent mediation authorities are there.
Mediation report is there, it has failed. Report is there.
Well, we have not seen the report. We are told.
No,
my last junior.
Yeah. Failed one. Order is passed in.
দেখে নিচ্ছি দাঁড়ান তুই দেখো তাহলে ততক্ষণ রিপোর্ট আছে কিনা আমরা অর্ডার শিটটা দেখি আছে থ্যাংক ইউ Very good.
Then, my lord.
Yes. Any other judgment you want to say?
Yes, my lord. Before that, my lord, a practical. In Odisha, about 21 years later, their incident where it was reported, my lord. the husband and wife, they're living together for 21 years. Then thereafter, suddenly the husband came to know that his wife has a relation issue. Well, what he did, this is a practical solution. He made the person concerned, her paramour, then they got them married.
Or the paramour married with his wife?
Yes, the husband initiated the marriage, because you see, after long 21 years, if
all husbands are not so liberal and all paramours are not so lucky.
Well, this is the practical solution. Je jete chahe take jete dao.
Cite the judgment on that. The judgments on that proposition also.
Paragraph 26.
My lord, kindly come to my lord, paragraph 23. 23. Kindly come to paragraph 23.
Rakesh Raman has been followed, right?
My lord, according, my lord, this was a Narayan Bhumik, you will say Aparna Chakraborty. Now, my lord, this is reputable, my lord, from website we have downloaded it, my lord. My lord, according to a coordinate bench of this court in this case of Rakesh Raman versus Kovita has observed that where the parties have been living separately for the past 25 years, marriage is only on paper, and such relationship must be taken to have broken down irretrievably long back. It was further observed that such a marriage.
No, this will not help you, because here ultimately, after observing everything, in para 35 court says in exercise of its power under 142.
That no, my only thing is this.
Rakesh Raman
the principle is let down. Now, my lord, it is open. Now it is not confined to 142. My lord, what I am saying, my lord, here the principle let down, my lord. Equal to both parties, it is there for ground for marriage under section such. The observation of the court was squarely applicable to the fact that even in the parties have been living separately for better part of the lives. Well, we have been better part of the cream period, my lord. Then, my lord, kindly come to next paragraph, my lord.
Judgments cited are all on 142.
Yeah. Now, yes.
That precisely happened in the next judgment. The first
only thing, my lord, only thing is this is my principle let down. Rakesh Raman, my lord.
Navin Kohli, everywhere. All the other judgments.
My lord, now only thing, my lord, para 24, my lord, their conduct amounts to cohabitate with each other, my lord. In the case that spouses have strongly advised that we regard to approach to us.
This is a continuation of 23.
24 and 25. Yes. My lord, only thing is this, my lord, our cases, we had been a Kovita, Rakesh Raman. Now, the point
Rakesh Raman is sufficient for
yes.
Rakesh Raman is the only judgment where it was categorically laid down that it was.
So, my lord, here, kindly have a look at down.
Yeah,
yeah, both.
Para 26.
Para 26.
Yes.
My lord, your lordship was looking at 26, para 26. Amar Ghosh versus Jaya Ghosh.
23 to 24, we have looked into the judgment.
Anyway, my lord, only thing I have brought it, my lord, only to ascertain that the principles have been laid down.
Any other judgment?
And my lord, another thing, my lord. And my lord, here, this Rakesh Raman, my lord, kindly have a look at it. I have just taken pains to my lord, legal significance, kindly. Just what I am on, my lord. The legal significance, my lord, this has been summed up, my lord, here. Last, bottom. Yes. Desertion, the court reinforced that prolonged separation without reasonable cause constitutes desertion. And the judgment highlights the tension between professional obligations and marital expectations, but ultimately emphasizes that desertion is judged by conduct and intent to permanently forsake marital life. Peace and value staying there. Only thing is, well, this has been summed up.
Here, desertion cannot be taken into consideration unless as a ground of cruelty.
Yes.
Because if at the inception the suit was not maintainable under desertion,
well,
you cannot validate it.
Yeah, my lord, only thing is this, my lord, we have not been living separately. We are staying, my lord, for long 20 years, my lord. That's it.
Because today you have that Ratha Jatra resolution, we'll keep it on some other day for conclusion of our.
Another judgment. 84. My lord, kindly have a look at it. My lord, this is the 84 Supreme Court, kindly. My lord, kindly come to my lord, paragraph 10. Paragraph 10,
Paragraph 10, yes.
Paragraph 10, my lord, last, furthermore, Paragraph 10 was the last paragraph. Furthermore, we reach this conclusion.
Paragraph 10, last paragraph.
Paragraph 10, my lord. Paragraph 10
starts with in this appeal before this court.
Yes, paragraph 10, yes, my lord. Yes. Then, my lord, paragraph 10, last paragraph of the kind, last paragraph. Before 11, paragraph 11 starts.
Yes, furthermore.
Furthermore, we reach this conclusion that without any mental compulsion, because of it's evident that for whatever the reasons, this marriage has broken down and the parties can no longer live together. The parties can no longer live together as husband and wife. If such is the situation, it is better to close the chapter.
We reach this conclusion. What conclusion?
Well, conclusion is this: well, if they cannot live together.
No, what is the conclusion?
84.
Sentence starts with furthermore, we reach this conclusion without any mental compunction.
Well,
what is the conclusion?
Conclusion: the husband and wife, they are not in a position to live together. Relevant portion, paragraph 10. Well, in the head notes, can you have a look at it?
No, here this was a judgment of section 23(1)(a).
That
one cannot take advantage of one's own wrong.
The only thing is
that was disbelief.
The only thing I am relying on the principle laid down. If they cannot live together,
that is not the principle laid down here. Here the principle was that it was argued that the husband cannot take advantage of his own wrong under section 23(1)(a).
I am not on facts.
That is the principle. No, that is the principle laid down here. That is the conclusion. Court says that no, we cannot accept on facts as well as there is no legislation to that effect.
Facts are different. Only thing is this. That
not even fact, the conclusion is also different. This conclusion is arrived at. The conclusion arrived at is something else. That husband cannot be said to be guilty of his own wrong.
Here, only thing is this.
Here the court says we also don't hesitate. You have no mental compunction because marriage has broken down. It was never that marriage has broken down is a good thing.
Only thing is that they are not in a position to live together. So if they cannot live together, so it is better.
Marriage was not dissolved on that ground.
No. Then, my lord, last but not the least, my lord, I am coming on another.
You give another copy of this.
My lord?
You give another copy. You have given a different judgment.
Sorry. My lord, I have not given. My lord, I am giving.
And you give.
I beg to be
give another second copy of the other judgment to me. You are going to cite next Horendranath Bormon?
No, my lord. No.
You are not going to cite?
No. What?
This one. On the side. Yes. Anything else?
Oh, my lord. This one. Yes, I am going to say this one. Yes. Well, I am sorry to say.
Don't multiply judgments unnecessarily.
No, my lord, here the
principle. We have a tendency of diluting the case.
Only thing is this, my lord. I am trying to impress.
Both the judgments you have cited are directly not relevant. If you go on citing these judgments, then you will forget what is there in Rakesh Raman.
Well, only thing is this, I am trying to impress upon lordship. If the husband and wife is not.
We are already impressed on that. But other judgments on what point?
This is my lord only.
This point.
Just observation, my lord, just kindly. Oh, yes. My lord, this is our Calcutta High Court. Kindly have a look at it. Only thing is, my lord, I am on, my lord. If the husband and wife is not in a position to live together, it is better to live separately and start a new life.
Which paragraph of this?
My lord, kindly come to my lord. Second page, my lord. The paragraph 4, second page. That irrevocable breakdown of marriage by itself is not a ground for dissolution under the Hindu. Then, my lord, my lord, kindly come. My lord, kindly come to paragraph 5. My lord. Paragraph 5. Even before the observations of Supreme Court in Sarojini versus Adire extracted, the judges have, because have almost unhesitatingly expressed their preference for the view that where the marriage has for all practical purposes become defunct de facto, the court should be empowered to declare it to be defunct de jure. For example, in the Delhi High Court full bench decision in Ramkali versus Gopal, such and such, it was observed it would not be practical and realistic. Indeed, it would be unreasonable and inhuman to compel the parties to keep up the facade of marriage, even though the rift between them is complete and there are no prospects of their living together as husband and wife. This full bench decision of the husband and wife, the rift between the is complete and there are no pressure live together husband and wife. This Delhi High Court full bench decision in Ramkali versus has been approved by the Supreme Court in Dharmendra versus Usha EIR. My lord, only thing, my lord, what I am.
All the subsequent paragraphs, the court goes on to hold that although that can be considered, that has to be considered coupled with the other grounds. By itself, it is not a ground of
Yes.
So this goes against
only,
you.
My
This goes against you.
No, the only thing is this, what I want to impress upon your lordship is this, the Kavita Raman, that only thing is if they are not.
And it ends in para 18 where it's the court holds,
Well,
as pointed out, however desirable it may be, irretrievable breakdown by itself and without more has not as yet been made a ground of divorce, and the court must find out one or more of the grounds as specified in the other clause, the provisions of the statute, unless mutual consent. So this goes squarely against you.
Well, only thing the principle laid down is this. Principle laid down is
Principle laid down is squarely against you.
And
it says irretrievable breakdown by itself is not a ground.
In irretrievable, there were the latest judgment, my lord, that your lordship has that judgment has clearly specifically spelled out that. No, well, only thing is that your lordship kindly look into it, that if they are not in a position to live together.
Yes, why are you repeating that you already?
Live together, what is the use of continuing as a paper marriage? Nothing else.
Learned counsel for the appellant concludes arguments, full stop. Since none appears for the respondent at the time of call, comma, as a last chance to the respondent to contest the appeal, comma, the same is adjourned till July 22, 2026 as a part-heard matter, when it will be listed as a part-heard matter. Full stop. In the event the respondent chooses not to appear on the returnable date, comma, the arguments will be concluded. Arguments will be closed. Thanks.
I am appearing for the respondent, my lord.
Respondent.
Yes, my lord. And you has given the direction on 2nd July.
Yes.
Have the copy with AD. And I have.
But today also you have a resolution. What can you do?
I know that, my lord, but I have had the copy. I am giving the affidavit of service.
Affidavit of service filed to be kept on record.
And if it's on 20.
They have received.
They have received, my lord.
The respondent herself.
Yes.
Himself.
Came yesterday. I saw her.
From the same comma, it appears that the respondent has been duly served a notice about the pendency of the appeal. Full stop. Despite the same comma, the respondent chooses to remain unrepresented. Full stop. As a last chance to the respondent to argue the
petitioner.
Sorry, respondent বদলে appellant হয়ে যাবে যেগুলো as a last chance to the appellant to argue the appeal, comma, the same is adjourned till July 15, 2026, July 22, 2026, with the rider that in the event the appellant chooses not to argue the appeal on the returnable date, comma, ex parte orders may be passed in the absence of the appellant.
Hello, that means it will appear on 23rd.
22nd.
My 22nd, I have a fixed matter. My
23rd, 23rd. 23rd. Next.
But I appear for the appellant.
Yes.
For the defendant respond.
Right.
Well, this is an appeal from an order by which my suit for specific performance was dismissed. Well, I have prepared a short list of dates for your lordship's convenience.
Thank you. Yes. Yes. He is to be given a copy also.
Lordship.
Mr. Manoj Roy is not there.
That's it.
Your learned junior is not there, Mr.
He was here
He'll come. Yes.
missing. This an agreement for sale was entered into by and between the parties. I shouldn't say between the appellant and the predecessor in interest of the respondents on 15th May 2002. That is at page 75 of the paper.
75.
75.
Yes. Yes.
Then, Millard, at the time of execution, a check for rupees 2 lakhs was handed over to the purchaser, vendor by the purchaser.
Yes.
That is at page 130.
Yes, Mr. Court.
Then, Millard, after 1 year,
1 year.
a
Yes.
letter comes from Sanchoita Chaudhary, learned advocate, on behalf of the plaintiff, the then owner, addressed to the plaintiff, recording that since the check for sum of rupees was issued not by Chandranath Dotto, that is the plaintiff appellant, but as a partner of Sani Trust, the vendor being Shantiman refused to encash the check. Further, Smritimoy Mojumdar intimated the appellant that if the account pay check for the amount for the personal account of the appellant was not received within 30th June 2002, the said agreement for sale will be treated as cancelled. That is at page 105.
Yes.
Then Millard, the reply thereto. 16 June 2003. Letter issued by the advocate for the appellant to the advocate for the respondents, denying that there is any fraud in issuance of check, since the check was issued at partner by the appellant plaintiff of Sanitas. It was further denied that the appellant has ever asked to cancel the check with a promise to send a bank draft for the amount within 15 days. Then 16 July 2003, title suit number 39 of 2003 file, that is at page 127A.
So, sorry, page?
Page 127A.
Yes.
Then 12th August 2004, written statement filed by Smritimoy Mojumdar, page 8 to page 13A. Then Smritimoy Mojumdar died 5th of March 2010. That your lordship will find at page 39. On the death of the defendant, the heirs filed the written statement, page 5 to 223. Judgment delivered by the learned civil judge, that is at page 53. Now, Millard, I'll first place.
Only one thing, Mr. Court, the letter, your reply, that letter is at page 16th of June 2003?
Page 108.
Yes. Yes, please continue.
Millard, I'll first place the agreement for sale.
Why was the suit dismissed? Primarily on what ground?
Millard, primarily the check was issued from a partnership account.
On that ground, it was dismissed.
Yes, that there is no consideration because the check was not encashed by the defendant.
All right.
Millard, I'll place the judgment, Millard, from it. It will appear, Millard.
Yes.
First, I will come to page 15, Millard, the agreement for sale. Sorry,
75.
I think I have missed it. Plaint is at page 1. Page 1.
The agreement is at page.
I'm sorry.
79.
I'm sorry. 75.
No, 79 in our paperwork.
79, yes.
Yes.
Lord, may I place this agreement? This agreement made this 15th day of May 2002 between Smritimoy Mojumdar, son of Nolini Behari Mojumdar, since this is by faith, Hindu by occupation, service, residing at 154C Rajbir Avenue, Police Station, Lake, Calcutta 70029, hereinafter referred to as the vendor, which expression shall, unless excluded by or repugnant to the context, shall be deemed to mean and include his heirs, executors, administrators, representative of the one part, and Chandranath Datta, son of Rishikesh Datta, since deceased by faith, Hindu by occupation basis, residing at 8A Malapada Lane, Calcutta 700012, the purchaser. Then, my lord, I'll at page 82, my lord. Now this indenture witness it, and it is hereby declared by and between the parties as follows. The vendor agrees to sell, and the purchaser agrees to purchase. All that the land with the building being premises number 154C, Raspberry Avenue, Calcutta, more fully and particularly described in the schedule hereunder written, free from all encumbrances, subject to the approval of title by the vendors or advocate, Mr. D.K. Day, at or for the price of rupees 19,50,000 only. The purchaser has this day paid to the vendor the sum of rupees 2 lakhs, only the receipt whereof the vendor doth hereby acknowledge by the memo of consideration mentioned hereunder by way of earnest money, and in part payment of the consideration money, and the balance consideration will be paid within 8 months from the date of execution of this agreement and or at the time of execution and registration of the necessary conveyance for sale, and the vendor will be bound to effect registration of the deed of conveyance at the cost of the purchaser immediately after execution of the deed of conveyance.
This earnest money, Mr. Cord, you paid by from the partnership account. 2 lakh.
I will show that that is at page. That is at page 130. Page 130. Has your lordship got it?
Yes, yes.
This is the check. It is signed by Indranath Mullik and Chandranath Mullik. $2 lakhs. 15th May 2002. It's on Standard Chartered Bank.
And this was acknowledged in the memo of consideration.
Memo of consideration, my lord, your lordship will find.
Page 85.
Page 84 is the schedule.
85.
And page 85 is the.
No.
My lord, it's a very small property. It is at page 84, my lord.
And this gives the details of that check.
That is so, my lord. This is the
property and small matter also. Point involved is also very small. So you have paid the amount.
2 lakhs was check, but the check was not encashed.
That is their problem. I mean,
yes, my lord.
It was dismissed. It was dismissed only on that ground.
Yes. And the agreement was not registered.
Suit for specific performance. 49 proviso.
Lord, and stamp, not adequate stamp in the agreement. These are the 3 grounds of dismissal of the suit.
But it was never impounded?
Never impounded. On the contrary, by consent, the document was tendered. They came up before your lordship on that issue. Your lordship had dismissed their application. I'll show that order.
We think we can come to the judgment and to that order, Mr. Gowda, instead of wasting our time in this.
As your lordship.
If necessary, we can come back anytime. You can come back anytime to the agreement.
I will be coming to the evidence part because.
Yes.
Yes, for this reason, my lord.
Yes.
That a case has been made out in the written statement that I had agreed to replace the check.
By a bank draft.
By a bank draft.
Yes. Which you
and
denied
that
him
case
to
has
reflect
not
it.
been cross-examined when the witness was in the box. Carapet.
That Carapet. So their witness came to the box.
My witness, when
No, they also adduced independent witness.
my witness was there. This case was never put to him.
No, Mr. Kaur, this
Lordship,
case was
I'm
never.
sorry. I'm sorry.
No, this case was never put to your
Witness.
Understood. Did they adduce any independent witness of any evidence of any witness?
The original defendant died. Somebody else came.
Somebody else came. Did he make out a case of this case that
This case was never
made out by their witness also in their chief?
No.
That check replace and this request?
Lord, I had a cross-examined their witness. My witness was never cross-examined on this issue.
No, that we understood.
Yes, I'm sorry.
That's a given. This is the second question. Did their witness say anything about that?
I will place the
We'll look into that. So your witness, no suggestion was put to your witness on that.
No suggestion was put.
But that was not one of the premises on which the suit was dismissed.
That is not the premises on which dismissed. But I would be relying on Carapet for the proposition that if the suggestion is not given.
Yes. To be admitted. Taken to be
Lord,
admitted.
I will place only one paragraph of the written statement before I proceed further.
Absolutely, yes.
Lord, paragraph page 16, my Lord, written statement of the original defendant. I'm sorry, it is not. Lordship will give me a minute.
Yes.
Page 9, your Lordship will come, paragraph 9. Agreement is accepted. May I read the paragraph, my Lord? Paragraph 9. With regard to other allegations made in paragraph 2 of the plaint, the defendant states
yes,
that the defendant entered into an agreement on 15th May 2002 for sale of premises number 154C Raspberry Avenue for a total consideration of 1950 only to the plaintiff. Before the execution of the agreement, it was agreed between the parties that the plaintiff would pay a sum of rupees 2 lakhs as an earnest money. The plaintiff handed over an account pay check for 2 lakhs of rupees only at the time of execution of the agreement. Subsequently, the defendant noticed that the said check was not issued by the plaintiff, but the check was issued from the account of one Sani Trust. The defendant at once drew the attention of the plaintiff to the said illegal act of the plaintiff and fraud practice on him by the plaintiff. At this, the plaintiff asked the defendant not to encash that said check and promised to send a bank draft for the said amount within 15 days. The defendant told the plaintiff that it is the bank draft, if the bank draft or an account pay check for the said amount drawn by him from his personal account was not received within 30th June 2002, the said agreement for sale dated 15th May 2002 would be treated as cancelled. The plaintiff did not keep his promise, and accordingly, the said agreement was cancelled on 30th June 2002. Lord, this case was never put to my witness. I'll show the cross-examination. The other paragraphs are not relevant, my Lord. And I'll show the two letters, which are advocate's letter exchange between the parties in between. The first one is at page 105. Has your Lordship got it, my Lord?
Yes.
This has been exhibited.
Exhibit 3.
This is written on behalf of the defendant. You and my client entered into an agreement on 15th May 2002 for sale of premises number 154C, Raspberry Avenue, for a total consideration of 19,50,000 only. It was agreed that you would pay a sum of rupees 2 lakhs only as an earnest money. Accordingly, you handed over an account pay check for 2 lakhs, only drawn on Standard Chartered Bank, Netaji Subhash Road, branch, Calcutta. Subsequently transpired that the said check was not issued by you in your personal capacity. On the contrary, the said check was issued from the account of one Sani Trust. My client at once drew your attention to the said illegal act and fraud practiced on him, and my client refused to encash the said check. And at this, you asked my client to cancel the said check and promised to send a bank draft for the said amount within 15 days. My client intimated you that if the bank draft or an account pay check for the said amount drawn on you from a personal account was not received within 30th June, the said agreement for sales dated so and so would be treated as cancelled. This case was never put to my client in the cross-examination. Lord, this was replied to.
Yes, you said that you had the temerity to file a false police complaint. No, we have just
looked into.
Yes, temerity to do that, and the police dropped the case. Did not pursue the complaint because it was false, and you have categorically denied it's a tissue of falsehood. There is a language used.
Lordship is quoting the language.
Yes, we have seen looked into it. So you have squarely denied. They did not put in your evidence. So Carapiet applies squarely. That is your case.
That is first.
That is
Second
first.
is
Yes.
The agreement is not registered. Section 54 of the Transfer of Property Act.
Section 54 does not require agreement
to be registered.
And Section 49 proviso of the Registration Act also says that in a suit for specific performance of contract, you need not have it's not mandatory to have a registered.
That's right. And Millard, I will also cite in case.
Yes. In case we don't understand. No, sir, please.
In case.
Yes.
It is argued.
Yes.
I might say 2025. SCC online, Supreme Court 1879. বাকি কপিগুলো Millard, I'm in difficulty. My other copies have not come.
What is the cited reference you can give us?
Yes, Millard. 2025 SCC online, Supreme Court 1879. Millard, may I read this paragraph and
we will try to find it out in our gadget. Give us 1 minute.
2025.
Yes, there's a little bit time lag. Just give us half a minute. We'll try to find it.
SCC online, Supreme Court 1879.
Just give us half a minute, Mr. Court. We'll just tell you when we find it out.
As your lordship got it, Millard.
We'll take some time. There's a internet lag. So
I see. I will place it.
Half a minute. We'll just find out. Yes.
I'll place it later, Millard, in that event.
No, why? Just wait. The problem.
May I come back within 5 minutes?
Yes, why not?
Yes.
Absolutely. Which court?
Court 24 minutes.
Go.
Just coming.
Has your lordship got it, Miller?
Yes.
Paragraph 10 of the judgment, Miller. Upon, may I quote, Miller?
Please, please, please.
Upon hearing the learned counsels appearing for the parties, and on perusal of the material evidence on record, the following points would arise for consideration. Whether the impugned document, agreement for sale, general power of attorney, receipt of consideration as registered, will allegedly entered into by Kundan Lal in favor of the plaintiff would confer a valid title over the suit property. Whether the plaintiff can claim any benefit under section 53 of the transfer of property, which deals with part performance, to what relief the parties would be entitled. Then, my lord, paragraph 12, agreement for sale.
Under the Registration Act, under section 454, no doubt you are not required. Under the Registration Act, probably, what was the date again of that agreement for sale?
The agreement was at
2002.
2002.
So under section 19, probably it's 17 or 19. You are probably required to register it.
Lord,
if it intends to create a future right also in immovable property, Registration Act.
It's not a transfer. Supreme Court has held that it is.
No, it's not a transfer. But under Transfer Property Act, it's not required. As a document of transfer, it is not required to be registered. But under, I will just come into that provision. Section 17 of the Registration Act, Mr. Kaur.
Stamping is necessary now.
No, Registration Act, you are saying. Other B, 17B, other non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or interest, whether vested or contingent, of the value of 100 rupees and upwards to or in immovable property.
Transfer interest.
Transfer interest,
yes,
whether in present or in future.
Yes, no.
So an agreement purports to create an interest in immovable property in future. So therefore, it can come under 17(1)(b) that will be argued by Mr. Banerjee.
Lord, Supreme Court has held that it does not come.
Under section 54, it does not.
No, not under 54.
Let
under 17 also.
Please cite that.
Lordship will kindly come to paragraph 12 of the judgment.
54, there is no doubt. It's very clear. No, but 12, 13, these are on 54 of Transfer Property Act.
Lordship.
Not required to be registered
under 54.
Because sale deed, Mr. Kaur, as we all know, is required to be registered under section 54 as well as under the Registration Act.
Lordship.
Here, under section 54, under the Transfer Property Act regime, it's not required to be registered. But under Registration Act, it's required to be registered. This judgment is on Transfer Property Act. Does it touch upon Registration Act? No.
Yes, my lord. I will. Let me place the section. Let me place the judgment, my lord.
12, 13 you have seen. You can come direct to the registration portion. And we agree with you.
Yes, my lord. This has categorically held that no registration is necessary.
That's a fair. Will you place in your own names? Yes.
My lord, paragraph 12.
Yes.
Of the judgment.
Yes.
The transfer of immovable property inter vivos is governed by the Transfer of Property Act. Section 5 of the TP Act defines transfer of property as follows. In the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself and one or more other living persons, and to transfer property is to perform such act. The TP Act envisages 5 different modes of transferring a property, but the purpose of the present appeal, we are only concerned with one of the modes, that is by a sale, and the same is dealt under section 54 of the Transfer of Property Act, which defines sale and a contract of sale as follows. Sale defined, then section 54, sale how made, then contract for sale. A contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. It does not of itself create any interest or charge on such property. Perusal of above said provisions lays down a specific mode of execution of sale deed with respect to immovable property for concluding the sale of a property. In sale of an immovable property, the value of which exceeds 100, the three requirements of law are that the transfer of property of sale must take place through a validly executed sale deed, that it must be in writing, properly attested, and executed sale deed, and registered. Unless the sale deed is in writing, attested, and registered, the transaction cannot be considered constituted sale, or in other words, the property will not be transferred. There is a difference between a sale deed and an agreement for sale or a contract for sale. Paragraph 15 below. A contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. While a sale is a transfer of ownership, a contract for sale is merely a document creating a right to obtain another document, namely a registered sale deed, to complete the transaction of the sale of an immovable property. Section 54, in its definition of sale, does not include an agreement for sale and neither confers any proprietary right in favor of the transferee, nor by itself create any interest or charge in the property. If after entering into a contract of sale of a property, the seller, without any reasonable excuse, avoid executing a sale deed, the buyer can proceed to file a suit for specific performance of the contract. The scope of an agreement for sale has been highlighted by this court in the case of Suraj Lamp and Industries Private Limited through Director of State Area, wherein the court observed that Section 54 of the transfer makes it clear that a contract of sale that is an agreement for does not of itself create any interest in or charge on such property. This court in Narayan Das versus S.A. Compton, 1977, Volume 3, Supreme Court Cases 247 observed, a contract of sale does not of itself create any interest in or charge on the property. This is expressly declared in Section 54 of the Transfer of Property Act. The fiduciary character of the personal obligation created by a contract of sale is recognized in Section 3 of the Specific Relief Act and in Section 91 of the Trust Act. The personal obligation created by a contract of sale is described in Section 40 of the Transfer as an obligation arising out of contract and annexed to the ownership, but not amounting to an interest or easement therein. In India, word transfer is defined with reference to the word convey. The word convey in Section 5 of the Transfer of Property Act is used in the wider sense of conveying ownership. That only on execution of conveyance, ownership passes from one party to another. Paragraph 18. It is thus clear that a transfer of immovable property by of a sale can only be by a deed of conveyance. In the absence of a deed of conveyance, duly stamped and registered as required by law, no right title of interest in the property can be transferred. Then paragraph 19. Any contract of sale, agreement for sale, which is not a registered deed of conveyance, would fall short of requirement of Section 54 and 55 of the Transfer of Property Act and will not confer any title or transfer in interest in immovable property, except to the limited right granted under Section 53A of the Transfer of Property Act. According to the Transfer of Property Act, an agreement for sale, whether with possession or without possession, is not a conveyance. Section 54 of the Transfer Act enacts that sale of immovable can be made only by a registered instrument and not by an agreement for, and an agreement for sale does not create any interest charge on its subject matter. In the instant matter, undisputedly plaintiff claims that there is only an agreement to sell and there is no sale deed executed in his favor by the father. As per the settled position of law, this document does not confer a valid title on the plaintiff, as it is not a deed of conveyance as per Section 54 of the Transfer of Property Act. At best, it only enables the plaintiff to seek for specific performance of the execution of a sale deed and does not create an interest or charge on the property.
Mr. Court, in this judgment, the issue which fell for consideration was point number 1, whether title passes by virtue of an agreement for sale.
Lordship.
That was answered in the negative by observing that title only passes by registered sale deed and not an agreement for sale. That was the issue. This issue was not under consideration whether an agreement is independently required to be registered or not. Here the Honorable Supreme Court said no, whether title can pass through an agreement, no, it cannot. 54 is there, and only by registered deed, sale deed, it can pass. That was the issue. This is not German in the present context.
My lord, here, in the present case, my lord.
Present case, it is not, nobody's case that title passed.
Nobody's case.
So this judgment is not German.
Because the judgment.
This does not waive the requirement of registration in respect of an agreement for sale. This never says so. It says title only passes by a validly registered transfer deed. Nothing else. Our proposition has to be read in the context of its facts, Mr. Court. And the question which fell here is whether title passes through an agreement.
It does not.
Now, 7 paragraphs were required, but Section 54 is sufficient.
Now, my lord, this judgment was cited by me only to show that agreement for sale does not require registration, which has been held by the Supreme Court to be valid.
With due respect, Mr. Court, this does not hold so. It does not at all hold so. It says title does not pass except that you have a registered sale deed.
My lord, if your lordship
it never says it does not require an agreement. Under the Transfer Property Act, yes. But under Registration Act, do you have a copy of the Registration Act, Mr. Court?
Lordship, if your lordship allows me to place the section, the judgment once more, only a part. In India, page.
Yes, paragraph.
Paragraph 16.
Yes.
A contract for sale does not itself create any interest in or charge on the property. This is expressly declared in Section 54 of the Transfer of Property Act. The fiduciary character of the personal obligation created by a contract for sale is recognized in Section 3 of the Specific Relief Act 1963 and in Section 91 of the Trust Act. The personal obligation created by a contract of sale is described in Section 40 of the Transfer of Property as an obligation arising out of contract and annexed to the ownership of the bird, but not amounting to interest or easement therein. Therefore, my lord.
Agreed. How does it help you?
Therefore, if it is not a transfer,
that you are deducing that from this judgment. A judgment is only a binding precedent for the proposition laid down therein. Here it says transfer cannot pass except by way of a valid registered deed.
Title cannot pass except by a contract.
Agreed. But Mr. Do you have a copy of the Registration Act? Please let us come to that.
I don't have it.
Registration Act down or no? Thank you. Yes. Mr. Court, please come to these sections. Just give us 2 minutes. We'll convince
17.
you that you have a better case otherwise also. Please come to section 17 once.
17(1).
17, yes. 17(1)(b), small b.
Lord, 17(1).
We are just reading it out for documents of which registration is compulsory.
Compulsory register.
The following documents shall be registered if the property such and such. Now,
instrument of gift.
B.
Other non-testamentary instrument which purport or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest which vested or content, whether vested or content of the value of 100.
Now we are reading from here only choosing, picking and choosing the paragraphs, the phrases applicable to you. Other non-testamentary instruments which purport or operate to create, declare, assign, limit or extinguish, whether in present or in future, any right, title, interest in immovable property.
Now, my lord,
Your deed agreement creates a future right. It creates a right in future, whether in present or in future, any right, title or interest, not merely title, right, title or interest, whether vested or contingent. Your agreement for sale creates a right to be
to
performed,
obtain another document for
to
transfer of the
obtain a
property.
deed. Therefore, this, because then therefore it creates a right in respect, a future right in respect of an immovable property of 100 rupees and above. So therefore, an agreement for sale after this amendment, after this introduction of this, Mr. Kaur, is also required to be registered. But now please come to section 49 once. 49.
That 49.
49 says, effect of non-registration of documents required to be registered. No document required by section 17 or by any provision of the Transfer of Property Act to be registered shall A, affect any immovable property comprised therein, B, confer any right to adopt, or C, be received as evidence of any transaction affecting such property unless it has been registered. Therefore, not only under the Transfer of Property Act, but also if it is required under the Registration Act to be registered, and if it is not registered, shall not affect the immovable property, confer any power to adopt, or be received as evidence. Now, please come to the proviso of the same section.
Provided that an unregistered document affecting
Provided that an unregistered document affecting immovable property and required by this Act or Transfer of Property Act to be registered may be received as evidence of a contract in a suit for specific performance. Therefore, proviso saves you. 17B
has been accepted.
17B creates the fetter. 49 proviso removes the fetter in case of a contract if it is in connection with a specific performance suit. This is a specific performance suit. Contract which is otherwise required to be registered under 17(1)B, Mr. Kaur, can be received as evidence of the contract. And you are only required to prove the contract in a suit for specific. So therefore, this was not considered by the learned trial judge.
Yes, my lord.
So
Not by me also, my lord. I am grateful to you.
No. We are doing this regularly. That's why, sir. Only. So therefore, so we put the other side to notice also, Messrs. Banerjee, regarding this, because they'll have to answer it. That's why we put it to you also.
My lord, the other judgment I was.
Yes, Mr. Kaur.
Citing is
yes.
Is Carapiet's case.
Carapiet, yes, please say.
But before that, let me make out the case for Carapiet.
Yes.
Lord, the only case made out in the written statement I have shown.
Yes.
Paragraph 9.
9.
Now, my lord, now I'll place before your lordship the evidence.
Yes.
Of the plaintiff and the cross-examination thereof. That is at page 30. I have shown paragraph 9 of the written statement as
yes.
I have filed this instance suit. I have filed my affidavit in chief. I have gone through the contents made by my affidavit in chief. Then this is
your plaintiff case has
my evidence.
Right.
For cross-examination, page 31.
31, yes.
Exhibit was done by me in my personal capacity. Exhibit 1 is the agreement. It's a fact that is nowhere stated in the agreement that I am a partner of Sani Trust. Exhibit 1 is tendered to the deponent. It's a fact that it's not there in the deed as to which floor I got how much. In this deed, DKD was my learned advocate. Mr. DKD was my advocate. It's a fact that it's not written in the memo code that Sani Trust is giving the check. In page 33, I pay income tax. I pay income tax since more than 115, 20 years. I have all the documents of income tax. My agreement by dint of which I want to buy today is not mentioned in my income tax assessment. I have not given the check of rupees 2 lakhs in my individual capacity, but from my joint account, it is from the account of Sani Trust in UCO Bank on a Bowajar branch, and the check was issued. Sani Trust is a partnership firm from which the check was issued. I and my brother are partners of the partnership firm. The partners are brothers Indranath Dotto and Amarnath Dotto. It's a registered. The firm is unregistered firm. The check was not debited. There was no agreement on 15 January 2003. Lord, 2003 is about 1 year back. 1 year after.
15 January 2003.
ঠিক আছে. Then Exhibit 2 is tendered to the deponent. From 2002 February to 2003 January, I do not have swaps in my account. On 17 January 2002, my credit balance was so much. There is no reflection of my account before 2003 in the account, which is the name of myself and my wife. The last credit balance is 8,61,000. The account is shown in my wife's income tax account. I do not know the latest balance of the two accounts. I have not.
Mr. Kaur, you need not take the trouble. You have gone through the entire evidence. There is not a single suggestion regarding that.
Lordship.
We have seen it. If Mr. Banerjee shows something, you can, in your rejoinder, you can address that. I have not found any.
Case was not put.
Their entire pivot of their cross-examination endeavor was to was on that from the partnership firm. You have gave the money.
Lordship.
But we find from the records that Mr. Kaur, they issued a memorandum of consideration along with the agreement itself. Check has been exhibited. It is not anybody's case that that check was never tendered to them. Their case is that subsequently you said, don't encash it because I'll give you a bank draft, which has not been put to you in evidence.
Yes.
Now you can cite Carapiet.
Carapiet though.
I'll give you a copy.
Copy though. Carapiet. আরেকটা কপি দাও আছে আরেকটা কপি হবে
দিন দেখি ওটা দেখি হ্যাঁ
আরেকটা কপি দাও
দিয়েছি
কন্ট্রাক্ট একটা দিন
The relevant paragraph is paragraph 9.
Yes.
The law is clear on the subject. As you got it, Miller. Wherever the opponent has declined to avail himself of the opportunity to put his essential and material case in cross-examination, it must follow that he believes that the testimony given could not be disputed at all. Miller,
Carapiet is very well settled.
And Miller, this has been followed subsequently by the Supreme Court.
We have not heard of any case that it has not been followed or it has been distinguished, Mr. Kaur. That Carapiet is now set in stone. You want to cite the subsequent judgments also? Need not. Carapiet is, I think it's beyond.
2025.
Junior Mr. Kaur is wanting to cite something.
No.
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 Very well, sir.
Lord, therefore, the main, I'm sorry.
Give us half a second. Consideration is word. Because with consideration. Consideration to register দিতে হবে। যদি এগ্রিমেন্ট কনসিডারেশন ছাড়া হয় তাহলেও ভয়েড হবে না যদি আরেকটা ওইখানে দিয়ে দিতে একটা কপি প্রোভাইডেড এন্ড এগ্রিমেন্ট উইথআউট কনসিডারেশন উইথ কনসিডারেশন আর ভয়েড হচ্ছে কনসিডারেশন শুরু হয়েছে এগ্রিমেন্টের সঙ্গে মিনিমাম অফ কনসিডারেশন করতে এগ্রিমেন্টের মধ্যে এগ্রিমেন্ট তো অন কনসিডারেশন উইদাউট কনসিডারেশন উইথ কনসিডারেশন একটা আসছেই না আসছে কোথেকে কনসিডারেশন ছাড়া শুধু এগ্রিমেন্ট হয় তাহলে ভয়েড যদি তাহলেও ভয়েড না যদি রেজিস্টার হয় এটা তো উইথ কনসিডারেশন না না 25 ইয়েস 20 ট্রায়াল কোড রিলাই করেছে
Lord, may I now place the judgment of the trial court, my lord?
Yes, yes.
That is at page start at 53B.
Yes.
No, this is the decree, I'm sorry.
From 54 we
54, my lord.
yes. Need not
The
read the entire
plaintiff's
judgment.
case in brief,
Do you read need to read the entire judgment, we say?
my lord, only the, what is the ground in which
Yes, yes, those.
that first ground is the agreement is non-est because there is no consideration. Lord, I don't know how, why and how the learned judge has come to this finding that the agreement, there is no consideration. Because it has specifically stated.
Why section 10, section 19, everything has been stated, Contract Act.
That this contract is.
It is nobody's case that consent was obtained by misrepresentation.
There is no pleading.
Section 25 কোথায় রিলাই করেছে কোন পেজে? Section 25 of the Contract Act has been relied on. If without consideration, then void unless we raise. But if with consideration, 25 is not attractive.
I refuse to accept the consideration, and it is without consideration.
Yes. With consideration, section 25 is not attractive. Mr. Kaur, if you unless you want, yes, you want to add anything? All the quotations
page 56.
Page 56. Well, court merely recited all these sections of the 10, 19, 25. If with consideration, all premised on no consideration.
Lord, my submission on this is whether the agreement is without consideration or at all.
In the body of the agreement, it's written that they have received a portion. In the memorandum of consideration is there. Check, receipt is also admitted, but they make out a further case in their letter.
Receipt of check is also admitted.
That is what we are saying. Receipt of check, receipt is also admitted, receipt of the check. In their letter for the first time, they make out a new case that subsequently
It
you
was
say
agreed.
don't encash, I'll give a bank draft. You deny that in your letter, your reply.
That's it.
They make out that case in paragraph 9 of the written statement, but fail to put any suggestion to you.
That's it.
Therefore, Carapiet is attracted. And was there any DW1?
DW1,
DW1
only one.
DW1 never mentioned any. Did he mention in his evidence?
Yes. He is the son. He is not the original
No, even then, did he say that
No.
this happened, draft was given or?
No, I will place that.
They have placed the check. It's their document. Check is their document.
Jani,
DW1, what is the page number? Yes. Page 37.
page 37.
Yes. Constituted attorney. Son,
37
does it
is
say
the
anywhere that he has direct knowledge?
page 38, my lord.
38, yes. Constituted attorney.
My lord, this case 456
Hmm.
cannot stand in view of Carapiet.
Check. They are denial, yes. Yes, Carapiet also. Now, does he make out that case that subsequently it was?
Subsequent agreement is not in evidence.
Once union
তো বলেওনি ডাইরেক্ট নলেজ আছে
জানি আমি দেখিয়েছি ওটা দেখানো হয়
এটা করে নি বাবা সেটা করে নিয়েছে বলছে ঠিক আছে তো দেখছি না তো ডাইরেক্ট নলেজ আছে কিছু পারা প্যাটার্নের ভিত্তিতে কি করেছে
if I am not personally present.
47.
Subsequently, page 47, active evidence given. In fact, yes.
But the person given on behalf of the defendant,
yes
page 47, if your lordship can.
we are there
I am not personally present at the time of agreement.
yes and he adduces evidence on the strength of a power of attorney which is not tenable and not acceptable.
It's a fact that if there is any documentation over the property by Smritiman Majumdar, then it is binding upon the legatees. I know that it's a sake of Chandras.
Subsequently,
It is a fact that the amount of check was 2 lakhs. It's not a fact that Shantimoy Majumdar, Smritiman Majumdar encashed the check. I shall have to see as to whether I shall file the original check in the court or not. I cannot tell as to whether the plaintiff issued the check in his personal capacity or not, but their check from Sanitas. It's a fact that the check from Sanitas bore the signature of the plaintiff. It is not a fact that we did not intentionally encash the check.
And at page 48 he says no written document to show that father said that the said check had to be returned and a fresh check has to be issued.
That's right. Lord, I was relying on Carapet only for this purpose.
If you don't put it to the witness, then
That
you
is-
cannot
that is
independently
so.
make out a case.
Lord, those are my submissions.
Thank you. Yes. Yes.
So far as the legal proposition, my lord, advanced by my learned senior friend, I agree to my lord the propositions. Firstly, my lord, section 49 proviso that there's a proviso that in suit for specific performance it can be exhibited unregistered instrument. And so far as stamping, my lord, I tried, my lord, I filed an application because at the time of my lord exhibiting the document, my lord, objection was not raised, it was exhibited. Then an application was filed challenging that no, it cannot be, it has to be impounded. That was rejected. A revision preferred, that was also rejected. So when I came to your lordship under section 61 saying that in the appeal also it can be reopened, my lord,
Oh,
that was rejected by your lordship.
Why we were wondering why we did not. directed to be impounded.
We came before your
The
lordship
second round.
in the second round under section 61, my lord, saying that it should be reopened under section 61 before in the appeal
So
court.
you argued that very well. Now you regret.
But my lord, your lordship held that since, my lord, the revision was preferred, so
Closed.
it is
Yes,
closed
right,
chapter.
right. 61, you argued that 61 casts a burden on the court itself to look into
To
it.
look into the
It's a
document.
matter of revenue also.
Clear on a
Which
Supreme
is a
Court
good
judgment.
argument, but since your chapter
It
has
was
been closed.
Closed, your lordship. My lord. So, my lord, I had an advantage on that, my lord, but that is now gone.
Yes.
Now, my lord, the portions of the judgment, mainly the court has gone, my lord, on my lord, lack of consideration and lack of a valid contract. There are two other parts. From page 61 onwards of the judgment, my lord, second part is, my lord, that the consent was obtained by misrepresentation because he was trying to, my lord, facilitate a contract between Shoni Trust and my predecessor. That point was taken by me that actually, if a third party gives a check, Shoni Trust is not the petitioner, not the, my lord, plaintiff. So a check tendered by a third party. Maybe he is a partner, but the capacity is different. On that note, extensive cross was made to him, whether it was mentioned that trust is there, you will be tendering the check on behalf of the trust. Note that point, carapiet will not apply because extensive cross was there. Regarding the capacity, whether it was mentioned in the agreement, he has said no.
He was a joint signatory to the check
To the check.
in the
Right.
capacity of a partner of a partnership firm.
Partner or partnership? Two partners.
Is it material? Both partners
Both
signed.
partners.
Is it material, Mr. Banerjee, from where I pay? If it is I who pay, he tendered the check, you accepted it. You accepted the check as consideration as mentioned in the body of your agreement and in the memo of consideration. So you treated that check to be in satisfaction of that clause, earnest money.
May I
You
submit,
say I have already accepted that from whatever source,
may I submit this?
unless it's the PMLA proceeding.
When he is signing the check along with another partner, and not both are signing as partners with their stamp,
You
it
get
is
the
not a
money.
check by him,
You get the money all the
but
same.
the money was not accepted. He knows that the check was not in cash, and he also knows that it was
That's
not
your
received by
choice.
him.
You did not encash.
No, but the legal.
If you encashed, you would have got the money.
Personal capacity is different. The capacity as a individual and a capacity as a partner of a partnership firm.
Very well, Mr. Banerjee, if you purchase something from your wife's account,
These are not the same.
it's immaterial from where you get the money.
Not a general cause act also not considered.
Money was tendered by him. Money was tendered by him by way of a very well by the partnership firm on his behalf. How does it make a difference?
Because not the capacity changes, my lord, that it's the check, my lord, tendered by a third party.
You are stopped from saying that because you accepted that.
Very well.
In pursuance of the clause in the agreement, you say in the body, you sign the agreement. In the body, it's written, I have accepted this check. You give the check number. In the memorandum of consideration, you give the check number and say, I received the earnest money of rupees 2 lakh. So you are stopped.
So, my lord, the second part of the judgment was on that, my lord, that under section 19, the consent was obtained fraudulently because it was a third party. That is the second part. And my lord, the most important part, my lord, which the last part, although not discussed elaborately, is, my lord, the court has come to the finding that readiness and willingness was not proved. There is a finding on that, although not elaborate. Now, on that, my lord, if your lordship takes up the list of dates, one date is missing. That is, my lord, the agreement said the rest of the money has to be paid and document executed within a period of 8 months.
Yes.
That expired on 14th of December 2002.
We'll just come to that. Yes, 8 months. That is page 82.
14th of December 2002, this period of 8 months expires. If your lordship just not
We'll put it in our
kindly put this date, this becomes
14th of December. 14th of December
2002. Agreement was 15th of May 2002. 14th of December 2002, the 8 months expired. Now kindly comes back once to the agreement at page 78. The relevant clause.
Yes, page 82.
Page
Clause
82,
2.
it says categorically it has to be
Yes.
within 8 months. Now, my lord, they might take the point that the agreement, there is no specific clause that time shall be the essence of the contract. But the Honorable Supreme Court has said that merely because that is not mentioned in an agreement, that doesn't mean that the parties will not honor the terms of the contract. So, my lord, readiness and willingness, my lord, in the recent judgment of Jayamma, the Honorable Supreme Court has clarified readiness is, my lord, capacity, and willingness is the mental capacity or mental state of mind to enter into the agreement. He has failed, my lord, to establish either readiness or willingness. I'll show how. Because he has
Justice Mahadevan.
Justice Mahadevan, my lord. I
Yes.
have that judgment. That
Yes.
judgment, my lord, there's some paragraphs categorically says that you have to show that you were enough financial capacity to make the payment.
That is readiness.
Yes, that is there. He has disclosed some passbooks of the individual with with his wife, not the partnerships. Now the passbooks clearly show that on the date of the agreement, on the date of expiry of 8 months from the date of the agreement, or not at the time of filing of the suit, the consideration money was not there in the account. That is the only document that they have disclosed. If your lordship takes up the passbook, that is at page 91.
It continues from previous pages.
Yes, continues. But I'm on 90.
The relevant period. Right.
Agreement is May. So it starts from the 2nd May. If your lordship sees the balance is, my lord.
No, agreement is of 15th of May
2002. Lordship sees, my lord, from 24th May. He doesn't have even the earnest money in his account. This position continues, my lord, till
December. We have to see. December.
Lordship will not find that entry of December, my lord, in
18th January. Let us go up to that to give him benefit of doubt.
Page 91, bottom, my lord, 31st December.
Oh, yes.
That,
right.
2,817. Then, my lord, kindly, if your lordship turns 2 pages.
So 60,000, 6 lakh.
6 lakhs.
6 lakh,
He
2,000
just got
something.
6 lakhs on, my lord.
He had to pay how much?
19 lakh 50,000 because the earnest money, my lord, that was not encashed.
19 lakh
50,000.
No. Minus the earnest money?
17 lakh 50,000.
This was exhibit?
It's not exhibit.
Must have been, yes, exhibit 2.
Exhibit 2. Then, my lord, kindly comes to page 9.
Give us half a second, 1 minute. No, you said up to 14 December, yes.
December, and also after that, the suit was filing. Suit was filed.
Yes, after that also they have to show, yes.
From the date of the agreement, during pendency of the suit also. Entire period they have to show.
Rupees 17 lakh, how much?
17 lakh 50,000. In July, suit is filed. July 2003. It is not.
But the entire period it has to be proved, actually.
Entire period has to be there. Only 21st February, page 93, last entry. He has this amount. Page 93, last entry.
Achha.
That is not February 2004. But for a limited period. Immediately the money goes out. After that, again, he doesn't have. Specific questions was put to him, whether you have the consideration money, whether you have shown. He has said, no, I don't have the money. Since Lord Carapiet is not.
It was, he said.
Put to him. Although I say not for readiness and willingness, it is his duty not to prove.
No, but if he has admitted that, let us see that.
I'll show that. So, my lord, it is not there till, my lord, the end of this document. After that, it's never there. So, my lord, so far as readiness component is there, my lord. Now, I'll show that, not the cross.
You are showing what, judgments?
No, I'm going to judgment later. I'll show the cross, my lord, now.
Yes, that is what we are. Yes, we are precisely asking for that.
Page 24. Just a second.
Yes, take your time. You just show that portion.
Kindly comes to page 33, my lord.
33, yes.
First he says, in the middle, my lord, then says, after that, my lord, check was not debited. Then, my lord, after 2 lakhs, apart from 2 lakhs, which was not debited, I did not make payment to the defendant. I have filed passbook to show that the relevant time I had 90. First says, I had 19,50,000, contrary to the passbook. Then, my lord, this account is in my and my wife's name from 2002 February to 2003 January. I do not have 19 lakh in my account. On 17th January 2006, my credit is 2,52,000. 2006, up to 2006. There is no reflection in my account before 2005, which is in the name of my wife and myself. Last credit balance was 8,61,607. So he admits that he didn't have the money.
But Mr. Banerjee, yes, you are right. Throughout the period, he has to have. Does it mean that throughout the period, every day he had to have that
No,
amount?
not every day. Not every day. But my lord, within that period of 8 months, he has to. First part is, my lord, the Supreme Court says throughout he should be ready. And the notice that he gave in reply to my notice, he says that I am ready to execute the agreement immediately, the deed. If you don't do it, then I'll go for a suit for specific performance upon deposit of the entire money.
Mr. Banerjee, they could have taken a loan also. I mean, they could have organized otherwise, but that is probably contrary to Justice Mahadevan.
They have to show that they had the money.
Achha, this is on their cross-examination, this much.
This much, and last page 34 also, again, suggestion is given that you did not have the means to purchase.
Where is that?
Suggestion was last two lines.
Last two lines.
It is not a fact that because I had no means to purchase the property, I did not make such request. So extensively, suggestions were given. He was put on cross. This is readiness. So far as the bank pass, this is the only document he has exhibited. He has not exhibited that he had approached any bank.
No, he has not. So it's his
duty to prove.
Yes.
He has to plead and prove. So this part, readiness, he fails to prove. Now, willingness, my lord. So far as, my lord, the dates are concerned, my lord, agreement is in, my lord, 15th May 2002. Now, kindly, my lord, consider, maybe legally, partnership firm's tender might be legally taken to be, my lord, a tender. He has done it. But when the check is not encashed, is it not his duty to inquire that why you have not encashed the check? He says that after giving the check was not encashed, he was silent. Then the period of 8 months expires. He is silent. Within 8 months, he doesn't show any inclination to buy the property, not a single letter. Then he says in the plaint that on 10th of January, I have given a letter that I will purchase. That document is not executed. 10th of January 2003. That document is not exhibited. I deny the document in my written statement that it was never tendered. He says no, it was sent under certificate of posting. Not proved. Not tendered in evidence. Then my notice goes to him in June. So from January, after 14th December till June, he remains silent. No inclination to buy. That is willingness. No inclination. Up to June. Then when my notice goes, because I gave a notice because some persons came and disturbed and said that we will buy the property, they disturb our possession. We gave a notice. In reply, my lord, a notice comes from the advocate that no, all the allegations are denied. I'm always ready, throughout ready. And if required, I'll put in the money in the suit. I'll file a suit and I'll deposit the money. Kindly see that averment was made on a date when there is no money. In the notice which was referred to, 105, no? No, the 4th June. 105 is our letter, and their letter is the subsequent document. I'm giving the page. 108. Their letter. Specific averment is there that I'll deposit the money and I'll execute the.
In their letter.
In their letter.
Yes, yes.
I'll just show that line.
Yes, show that.
108.
Yes. Page 108.
108.
Starts that page.
Kindly comes to
page 109.
Yes, 109. Our client is ready and willing to pay the amount agreed to be paid under the agreement, but in view of the attitude displayed in your letter dated 4th June 2003, our client has been advised to file a suit for specific performance of the contract, if necessary, by depositing the entire consideration in court. But the consideration doesn't come. And on that date, on the date of the letter, as well as the date of the filing of the suit, the consideration is not there in the disclosed document. So I say, these things read together shows lack of willingness.
So willingness because they did not take any steps till June 2003.
Agreement says 8 months.
And readiness because they did not have the money in there.
And 8 months, after that, after 8 months, another 7 months. Nothing. Then my letter goes. Then reply comes.
Yes.
And he is advised by the lawyer to file a suit immediately. Why you have not filed the suit? But he has not shown anything before my letter. So, my lord, the element of readiness and willingness, my lord, are amiss. And my lord, the tender followed by non-encashment, my lord, has to be read along with this my lord, entire conduct of not paying the rest of the amount. Because he knows that the check has not been encashed. So he knows that ultimately he will have to pay the money. Because if the check is not encashed, the money doesn't go. Then he will have to pay, my lord, apart from that.
Not only that, no, suppose let us hold, so even if you hold against you on this money, no, you did not encash your choice. Why should they EQ further? But within that 8 months also, they did not write. Even many months thereafter, 6 months, 8 months thereafter, 8 and next June. So 8 months, 6 months thereafter, probably, or 8 months thereafter, they do not write by themselves. When you write, they write.
And on top of that, the document is not registered, not unstamped. And in the suit, he steals a march by not getting the document somehow exhibited. Not after that, not my client became wise, but
no, you lost the march, they stole it.
Yes.
You deliberately lose your march, they steal it. Rightly stolen. We are not on that. But this readiness ceremony, that is based and only. Where is the finding of the trial?
Finding, is very cryptic, my lord. After page 61, my lord. But I think these are courts.
So your client has grown wiser only after coming to this court. Every time he comes to you and your learned friend, he grows wiser.
There is finding in the judgment that there is no readiness and willingness proof. But these facts, my lord, of the money not being ready, that was not reflected in the judgment.
Where is the finding even?
Page 60.
Is there an issue framed on this?
Yes, my lord. Page 61 onwards, my lord.
Issue should be framed. It should first be, has to be framed.
Page 61 at the bottom. Secondly, whether the plaintiff has been ready and willing.
60.
61.
61 at the bottom. Secondly, yes.
Secondly, whether the plaintiff has been ready and willing to perform his part of the contract. And advocate appearing for the plaintiff rests his argument on this point. Plaintiff given account pay check. It is his case. Although the court has more information on the check by the Shoni Trust.
Thanks to you. Thanks to your arguments. I mean, your client's arguments.
But my lord, the fact remains that court comes to the finding that he was not ready and willing. And the reasons, my lord, in the court of my lord, first appeal, I can argue, my lord, on the facts also.
If those were on record, materials where everything was on record.
On record.
You're arguing on that only.
On record.
So order 41 rule 24 also. If there are materials on record, this court can itself pass whatever.
My lord.
Either way.
So, my lord, it ends at page 62 middle, my lord. There's finding that did not give any check in his personal. The finding is that he was not ready and willing. All the reasons, my lord, might be divorce, my lord, the materials on record. Then, my lord,
the court is enamored with that earnest money non-payment. Because of your convincing arguments.
That part only. But I say, my lord, that these facts, my lord, are glaring facts, my lord, which court has not gone into. But
rather, court has said you were always willing to, and plaintiff was not willing to perform the contract from the inception.
That finding is there. But the reasoning, my lord.
No good reasoning. Anyway.
Now, the judgment, my lord, I rely upon on this point. Yes.
But this readiness finding is vitiated by perversity. He relies only on honest money. Anyway, conclusion is correct.
SC online SC 1191.
Prashant Mishra, Justice Prashant Mishra, sorry. There are 29 onwards, right?
Here are not several judgments are quoted.
Yes.
Judgments not go in the same line that you have to show that you have the money. That is sine qua non.
We'll quote those judgments and this judgment in our.
I'm not there. So
yes.
Not reading this paragraph. Not because
readiness, willingness, para 29 onwards.
From 28 onwards, categorical finding. The paragraph 31, judgment of NP Thirukanagam was quoted. Several judgments quoted. Everywhere it is said that the money has to be there. They have to show that. And also,
yes, throughout the period, that also.
Throughout the period. That is
the relevant period, yes.
The entire relevant period.
একটা বলেছে এখানে বলা আছে যে জাজমেন্ট গুলো রেফার করছে তাতে বলা আছে প্লাস অন্য জায়গাতে আছে
The paragraph 37. Finding on
কিছু
that
জায়গায়
basis
আছে তো
correct.
কি বলতে হবে মানে প্রমাণ করতে হবে না বলে College sufficient. 37.
Para 37. In the present case, there is no material whatsoever to show that the appellant plaintiff had the balance well consideration available either at the time of execution of the agreement, within the stipulated period of 4 months for performance of the contract, or even at the time of filing of the suit in the year 1990. 3 stages. I'm not relying on this judgment, not the judgment has been delivered by your lordship's court. Recent judgment not yet reported. Unreported. Recent judgment হচ্ছে 8 July. So this is not in the case of Barhanur Rahman.
Oh, এটা
Jamma has been considered not in this case, my lord.
এটাই সাইড করেছে জানি
Paragraph হচ্ছে 37 to 42.
তারা 37 তারা 37 on
37 or 26 onwards is not time, but the time is essence of the contract. Where now Supreme Court, your lordship adopted the finding of the ratio of the Supreme Court that even if it is not written in the agreement, but parties cannot be reluctant or parties cannot be.
let us see that part also.
So that is not in the
Not in so many words.
What is the other Jayamma Supreme Court judgment? It is there in one.
The court jam also.
Yes, I'll in this minute, paragraph 26, 27, then lordship kindly comes to me, lord. (34)
Yes.
37 onward. Supreme Court, the paragraph I'll mention where it is stated.
Yes.
But paragraph 41, one judgment is quoted. I'm just reading, my lord. Paragraph 41 in Jayamma, not in your lordship's judgment. Jayamma. Says, my lord, it has been consistently held by the courts in India following certain early English decisions that in the case of agreement of sale relating to immovable property, time is not of the essence of the contract unless specifically provided to that effect. Period of limitation prescribed by the Limitation Act for filing a suit is 3 years. From these two circumstances, it does not follow that any and every suit for specific performance of the agreement which does not provide specifically the time is of the essence of the contract should be decreed provided it is filed within the period of limitation, notwithstanding the time limits stipulated in the agreement for doing one or the other things by one or the other party. That would amount to saying that the time limits prescribed by the parties in the agreement have no significance or value. They have to honor the terms of the agreement. Even if it is not mentioned, they have to honor. And here there is no attempt at all from their part.
No. You are mixing up two different arguments. One is time is essence. Another is readiness and willingness. These are two different arguments. There may be overlapping aspects of the matter, but time is the essence. You are saying that they did not do it within 8 months. They did not take any steps within 8 months. That is one argument.
Willingness.
Not only willingness, even otherwise, not on readiness and willingness. Even if they have the willingness.
To establish willingness, my lord,
willingness.
If they take the point that the agreement doesn't say that time is essence and it can be performed after the expiry of 8 months also, then also the parties have to honor the period.
You are right.
They have to show why they have not honored.
All right.
That is not there. Not
if the on a composite reading of the, because the earlier line of judgments as held here in para 41 is that the contrary thing has been
Contrary,
held.
that it has to be mentioned in the agreement.
But that has to be honored. So if we, on a conjoint reading, at least during the periods stipulated in the contract, they have to show their willingness.
Or immediately thereafter. But here, first letter
Immediately
comes in
thereafter.
June.
Even if not, the sale deed executed during that period, because that time is the essence for, or the actual payment is made.
Actual
They have to
payment is
show
made.
the
They have to
willingness.
show. So,
We are much after that.
I humbly submit that both the elements, readiness, willingness, are unavailable, not present in this case, my lord. They have failed to establish, and specific questions are put on that. 16C applies. Not the court has come to the correct finding, correct conclusion, my lord. The reasoning, my lord, might be, my lord, only that Shonit. That is the Shonit Dasha in this case for my client. But these are my submissions.
Thank you. Yes, Mr. Kaur, anything on that readiness and willingness?
My lord, if your lordship kindly sees section 16C of the amended specific relief.
No, only one submission, Lord, last submission, that we have by a letter say that if you don't make the payment, it shall be deemed to be cancelled. Earnest money that was mentioned at that point of time, then it has been deemed to be cancelled. So if there's a cancellation,
Exhibited.
In my letter,
In the first letter,
I have told you to pay the money. If you don't,
Yes,
it shall be cancelled.
Yes.
Automatically,
Consideration
it will be deemed to be cancelled. So, Lord, by the letter conveys that it was cancelled. But cancellation has never been challenged in the suit. They have not.
My lord, if your lordship kindly takes amended specific relief act.
Amended specific relief act section 16C still mandates you to prove it. Need not aver it now. Aver has been taken out.
Lord, who fails to prove 16C
Proof has been retained. 16C now
that
says
he has performed or has
previously it
been
was
ready and
never
willing to
approved.
perform the essential terms of the contract which are to be performed by other than terms the performance of has been prevented
Yes.
by the defendant.
Yes. But you fail to prove, that is their case.
No. Readiness, both. And where is there
Lord,
to it?
page 59 once.
59.
Last 3 lines.
Page 59. Last 4 lines.
Contrary.
Yes, Mr. Court. Last 59. Yes. Readiness.
The plaintiff proved that he has performed his part of the contract in conformity with the terms of the contract. Readiness to perform the contract cannot be questioned.
No, this is your argument. Continue. The paragraph starts with your argument.
Advocate.
For the defendant,
On the
appearing for the plaintiff.
No, learned, on the contrary, learned advocate appearing
his
for the
willingness to perform the contract is clear.
And it's a finding.
That paragraph starts with, on the contrary, learned advocate appearing for the plaintiff argued.
The allegation that along with the learned plaintiff pointed out.
Unknown. And this is. This is what it is. Then it comes to the finding.
It will be clear from the next paragraph. It continues. Learned advocate for the plaintiff pointed out. Not the finding.
That the power of attorney holder of the
Banerjee was taken out of.
it is no personal knowledge of the agreement.
Taken by surprise. Rather. It's not the finding of the court. Rather, it has been held, although on a different ground, pages 61 and 62.
Lord, page 61, your lordship will find it's on a totally different.
That's on a different ground, but the conclusion, if the conclusion is correct, Mr. Kaur, and the evidence is before us, why shouldn't we affirm that conclusion on the ground of readiness and willingness, if not anything else?
Lord, on the point of readiness, willingness.
Your bank accounts have been placed before us by Mr. Banerjee.
Milord, is it necessary now, after the amendment, for the specific
Proof? Yes. Oh, yes.
Continuous period? No, Milord. Not for the continuous period.
Continuous period
Of the entire period.
specifically.
Okay, specifically back now.
But this Joyamma judgment still stands. Anyway, we'll come to
16.
that. Yes, 16C. That has been held by courts in several judgments. Continuous period.
Milord.
Yes, 16C. 16C was previously also not continuous period. Previously 16C was who fails to aver and prove. Now it's who fails to prove. Aver and has been removed. Previously also the statute did not contain any mandate that it has to be, and it still says who fails to prove that he has performed or has always been ready and willing to perform the essential terms which are to be performed other than term. So
Yes,
this
but
always
he
has
is
been
ready and willing to perform.
yes.
That is
The
the
language
distinction.
of the section of the provision, section 16C, Mr. Court, has remained the same, exactly in toto same. Only ever and this expression has been removed. Therefore, you need not plead anymore. You need not plead in your pleadings. But you have to prove all the same. The rest of the language is same. Always has been ready and willing, and this has been interpreted by courts in Jayamma's judgment also and elsewhere also. You know very well. Till the filing of the suit, at least you had to prove that you were ready and willing.
Paragraph 31 of Jayamma.
Paragraph 31 of the judgment.
Paragraph 41.
No, 41 of another judgment was quoted there, probably.
Muhammad Khalil.
Paragraph 31.
Mr. Banerjee, 41 of another judgment was quoted, isn't it? Let us see.
41 of it.
No, we are wrong.
41 of this.
No, in paragraph 31, paragraph 5 of another judgment is quoted, which says entire.
My lord, paragraph 41 has been quoted.
No, no, paragraph 41.
I was referring to for
Oh, that was it. Time.
paragraph 31 of the Supreme Court judgment.
Yes.
Categorically, the quoted
Yes, yes.
last part is very clear. Amount of consideration we has to pay must of necessity prove to be available right from
No, that was during the aver and prove era. But still, the rest remains the same.
last part of this judgment. Quotation, quote. Last 5 or 6 lines of the quote. Paragraph 31, sir. 31.
আত্মারাম ইউজ করেছে দেখেছি আমি দেখছি
Yes.
Entire period.
There it's one step further, right from the date of the execution till date of the decree.
The relief of specific is one based on equity for enforcing contractual obligation. Paragraph 29. Required the person seeking performance to specifically aver and prove his continuous readiness to perform his obligation.
Yes.
The term readiness refers to the financial capacity and the term willingness reflects the conduct. Here, my lord, the judgment is quite categoric that judgment না না জাজমেন্ট না আমাদের পেপার বইটা আমার পেপার my lord, if in the judgment there is no pleading that I am not either ready or willing to perform the
In this judgment,
in the pleading.
you're pleading.
They are pleading.
Need not be. You have to prove your body.
No, my lord, unless it is pleaded.
Need not be.
Very well.
Previously, you had to
Very well,
plead.
I have understood, my lord. What you
Previously also they did not have to plead. Your burden, your initial onus.
Lord, you will give me a minute.
Yes, yes, please. Absolutely.
There is one paragraph of the judgment.
Page. 91 থেকে 93 হচ্ছে গন্ডগোলের কথা। 91 থেকে পেজ 91 থেকে 92।
Milord, if I may draw your attention, Lordship's attention to
Yes.
page 62.
Yes.
The learned judge has proceeded on the basis of agreement without consideration. Page 62. But nowhere has any discussion been made either regarding readiness and willingness or that they are not in a position to. As a matter of fact, in the evidence also, no questions were asked as to whether I am in a position to comply with.
Evidence Mr. Banerjee placed those portions. Page 33, 34. And it is you who produced your bank passbook or bank statement, whatever. Page 33 and 34.
Page 33.
Yes. That is what Mr. Banerjee was relying on.
Yes, my lord, page 33.
33 then says, from the middle, I have passbook to show just about the middle of that page.
In my account.
Yes, to show that at the relevant time, I had rupees 1950 in my account. Exhibit 2 is tendered then. Exhibit 2 is that passbook of yours or statement. Yes. From there, from page 91 to 93 of that is the relevant period. Relevant period means from execution of the agreement till filing of the suit. That period is covered, that 8 months. 8 months as stated in clause 2.
Balance is 8,61,000.
Yes, throughout that period of 8 months, it was not there. You did not have 1950 at any point of time. Before filing of the suit, if you continue further, before filing of the suit, Mr. Kaur, for a sporadic period, not even sporadic, once you had over that, 21 lakhs something. That is for probably a few days or a few weeks or something like that. But
Milord, here,
entire period and always ready and willing is not proved. Always ready is not proved by this. That is Mr. Banerjee's argument. Readiness means capacity, financial, and willingness not proved because before they wrote, there is nothing on record. You did not bring any exhibit on record to show during the 8 months period. You at least wrote to them that why you are not executing, or even after that, you waited for their letter to reply to that in which you insisted.
Those are the two letters, Milord. There are no other.
No,
there are no other correspondence.
No. So therefore, on willingness, he is arguing, Mr. Banerjee is arguing that you never wrote to them at all. Even if that period elapsed, whatever, after that you waited, they wrote, I am cancelling, then you wrote.
Milord, if your lordship is thinking of period for filing a suit, that's different.
No, throughout the suit, we are not saying. Till filing of the suit at least. One period, one entry in the passbook or bank statement shows you had 21 for a limited period. But we are first thinking of the 8 months period as stipulated in clause 2. As per Jayamma's judgment, although time may not be the essence of contract as such per se, unless it's specifically stipulated, but the parties have to honor that, at least express their willingness during that period. During these 8 months, Mr. Kaur, you did not write to them even.
No,
First.
I did not.
Secondly, you did not have that amount in your bank account as evident from the passbook exhibited by you.
Milord.
And also after that period. Much up.
After filing comes to the finding, the plaintiff given his stake in his integer capacity or
even after filing of
so the plaintiff cannot claim a readiness and willingness. There is only the point of readiness.
After filing of the suit also you had that 21 lakh.
The question of readiness.
In the question of readiness and willingness, my lord,
it starts from 61, readiness and willingness to perform.
Page 61, my lord.
Yes.
It is submission solo 59 61 it comes to the question of readiness and willingness. The answer to it is in this paragraph. Again, a contract.
Readiness and willingness
held on a different ground which you don't accept. But conclusion correct, we can supply reasons. One, Secondly, if sufficient materials are on record, Order 14 Rule 24 compels us to.
No, my lord, I am not on that.
All the evidence is on record. Everything is before us. It is not that we require further evidence or you are required to.
No. My lord, I was only trying
also
to
find
show.
it is willingness not established.
I was only trying to show there is a finding of the trial court regarding readiness and willingness.
That is your arguments.
No. This is
first
the finding that is only to the capacity of payment. This is on readiness which you're finding.
Lord, as a matter of fact, if your lordship sees page 62.
62, yes.
The finding.
The plaintiff did not give any check in his personal capacity. That is the finding.
Yes, readiness. No, wrong ground.
Readiness and willingness, there is no finding.
Previous paragraph, last sentence.
Lordship, the contract is an agreement creating.
Before that. But the plaintiff was not willing to perform the contract from the inception of the agreement. The previous sentence, that qualifies the defendant. So the conduct of the defendant was very transparent. He was always willing to perform his part. And the issue, the caption of those paragraphs is readiness and
that is, your lordship is performed his part. The plaintiff
performed his part, but the plaintiff was not willing to perform.
With the terms of the contract, as he did not make any valid payment toward the earnest.
Supposing even if the trial court did not come to any conclusion on this, we are the first appellate court last.
There is no dispute. I am not disputing that.
Therefore, unnecessarily for this, there is no scope of remanding.
Milord, my submission before your lordship is, firstly, the trial court has proceeded not on the basis of readiness and willingness at all. And there is nothing on record to show that I had failed to perform my part of the contract. My performance was first payment of earnest money and then the actual consideration. These are the two parts which is my liability under the contract. Because I had performed my part by issuing the check for 2 lakhs. Non-encashment is not my duty.
No, earnest money we are with you.
Therefore, their only other liability is to make payment under the contract.
You had to prove, as per section 16C as it now stands, you had to prove that you are ready and willing to perform the contract. Always ready and willing. This is the term used. We take that always to be from date of agreement till filing of the suit.
Very well, my lord, assuming that is.
You adduced evidence, you proved. How did you prove? You produced your bank accounts, from which it is found that that amount of money, the entire consideration was never there throughout the period till filing of the suit.
No, my lord, I am not going to argue on that.
So then you are deficient on 16C, Mr. Kaur, as it stands now.
Lord, question is whether I have to maintain the balance throughout the period.
Not for a single time, not a single entry till filing of the suit discloses that you had that amount at any point of time. We agree with you, Mr. Kaur. Every day you need not have that amount. We need not have. Not a single entry from the execution of the agreement till you could have pumped some amount there and you boldly exhibited that.
Not only that, Lord, it may not be as it appears from the accounts. It may not be that in one account I did not have that money.
Right, we agree. But still, section 16C mandates you to prove. Otherwise, no degree of specific performance will be granted unless you prove readiness, always readiness and ready and willing. So where is the always component? At no point of time you had that amount. If you had to prove.
I had to prove, no doubt
about it. 16C you have to prove still. You did not prove.
Lord,
you could have produced other accounts. Yes, we understand. You could have had other accounts also. You could have taken loan also. But then you had to prove.
It's my wife's account is there. That evidence is there. Wife's account is there.
Where is that?
33 is the wife's account.
What was that?
33.
Account is in my and my wife's name. I mean, main
Show us any statement of yours in oral evidence that there is some other source.
এই যে 33 এইখানে 33 এইখানে last paragraph the accounts have not
You said
been lost.
this account is in my and my wife's name. The one
And the last line, my lord.
Last line.
Ah.
I have not filed the passbook of the two accounts to show the lender artist rated. Last line.
Which line?
The last line, my lord, of paragraph page 33.
I have not filed the passbooks.
Yes,
Then you did not prove.
to show the latest credit balance.
That goes against you.
No, your lordship has asked.
You have to prove. Where is your
Certainly, my
independent
lord.
statement?
At least this shows that I had two other accounts.
Need not. In your cross-examination, you say, I have not filed passbooks of two accounts to show latest credit. Where do you say in your chief or wherever? We don't find any statement. Where is the statement of another
Your
account?
lordship is right. Your lordship
You're
is
not
right.
finding any statement of another bank
No,
account being
what
there.
I was trying to submit before your lordship
Yes.
is that I have other accounts in which there are credit balance, which I have indicated.
Where you have indicated?
I have not filed the passbook of the two accounts.
But I have 19 lakhs. Operator, I have 19 lakhs. I have
Which
not-
two accounts are you speaking?
I have five,
Where is the reference to those two?
Miller page 33 by the middle. I
Middle?
have filed passbook to show
That
that at the relevant time, I had 19 lakhs 50,000 in my
in
account.
my account. The next sentence, this account is in my and my wife's name. That refers
This
to the
account is
previous
my
sentence.
wife's name.
So the account which you showed was in your and your wife's name.
Therefore, this amount was already there.
Everything you say after that refers to that account only. Now, what does these two accounts we don't understand? Two accounts, what does it
My
mean?
lord,
Is,
my lord,
is this document, is this account in your and your wife's name? Let us see that.
But it's shown in my wife's return.
it is shown in my wife's name. My lord, this 19 lakh 50,000.
Yes, so therefore this account is in your wife. You are referring to this account.
Yes,
So after exhibit 2 is tendered, you say this account is in my and my wife's name. From such and such, I do not have rupees 19 lakh in my account.
in my account, not in my wife's account.
No second account is referred to there.
Yeah, I do not file the passbook of the two
Mr.
accounts
Mr.
to show the
let us-
latest credit.
You are interchangeably referring to the same account as my account and my wife account.
No, my lord,
We are just reading the sentences. Please come to before exhibit.
specifically, my lord, if your
I
lordship,
have filed, you say, before exhibit 2,
lordship,
I have filed passbook to show that at the relevant time, I had rupees 1950 in my account. So you file a passbook to show it's in your account. Exhibit 2 tendered, then you say this account is in my and my wife's name. So therefore, the account to which you referred to in the previous sentence as my account is the same which you referred to as me and my wife's name in the next sentence. So you're interchangeably using my account and account in my and my wife's name. And then you continue to refer to that. On such and such date, I do not have rupees 19. Then you say there is no reflection of my accounts before 2005 in the account which is in the name of my wife and myself, which is the only account you have
and the
cited.
last credit balance is 8 lakhs and all
That account, that account.
in that account.
So everything, that account is shown in my wife's income tax account. So up to that, it's that account and that account only. I do not know the latest balance of the two accounts in 2018. We don't know what is that in that, what context that is in. And you have said in the next sentence, I have not filed passbooks of the two accounts to show the latest credit. There is no reference to the two accounts before that in your examination anywhere. Not a
But I
single
don't think I
statement.
can improve more on that.
We'll consider this, then we'll close arguments, we'll consider this. We'll have to see it. তোর সবকটা পয়েন্ট ডিল করতে নোটসটা ওখানে আছে আচ্ছা আনরেজিস্টার্ড আনস্ট্যাম্পড একটা আননেস্ট মানি একটা পয়েন্ট চেকটা এনক্যাশ করে নি ক্যারা পিরিয়ড জজমেন্ট গ্রেট হিয়ারিং ইজ কনক্লুডেড দ্য ম্যাটার ইজ রিজার্ভড ফর জাজমেন্ট খুব বেশি দিন দেরি করুন না।
My lord, item number 11, I am for the respondent number 1.
Yes.
Only single respondent.
Single respondent.
And co-former respondent is 4.
Appellant is not there. Let us adjourn for the day. Although the respondent number 1 is represented through counsel, comma, none appears for the appellant at the time of appellants at the time of call. Stop. Let the matter stand adjourned for the day. Next. You just give your name.
Remain in the list. Same.
Yes, yes, absolutely.
I am grateful to you, Lord.
In this matter, I am paying not today.
Not.
But I'm for the appellant. Plaintiff appellant. For partition that was been dismissed, hence the appeal. But if my lord may kindly takes the genealogical table, that will be very helpful for your lordship. My lord, insofar as the averments is concerned, my lord, what has been narrated in the plain has been accepted in toto in the written statement filed by the defendant number 1 and 2 as well as by defendant number 5. My lord may kindly takes the genealogical it is suit for partition and injunction. But the original order is Oshim Narayan Pandit. But he died in 23rd of January 1984. But the purchase deed of the Oshim Narayan Pandit was not being exhibited, could not be found out. That was one of the reasons why the partition suit was dismissed. But my submission will rest that it is an order, if the judgment ought to have been, degree ought to have been granted under Order 12, Rule 6, read with Order 15, Rule 1 of the Court of Civil Procedure. Why I tell you, Lordship? My lord may kindly see, Oshim Narayan Pandit died, leaving behind 2 sons, 2 daughters, and wife. Wife died, so the portion of the wife devolved upon 2 sons and 2 daughters in the ratio of 1/4 share each. Now, Apurva Narayan is the first son, eldest son. He died on 31st May 2023, surviving by the son of Arpan Narayan Pandit. He is the plaintiff. When a plaintiff, the second son, Oshit Narayan Pandit, is defendant number 1, having 1/4 share. That the daughter Rajashri, defendant number 2, have 1/4 share. Now, defendant number 1 and defendant number 2 jointly filed the one written statement. And the fourth daughter, Joyshri, he died, leaving behind the daughter and son. The husband has died. They are the defendant number 3 and 4. They have not filed a written statement. Now, the other portion is that, my lord, if my lord may kindly sees the 3 brothers of Oshim Narayan Pandit on the right hand side. But they are not the heirs on intestacy. They only one thing is that why I have made them they made Omyo Narayan son as defendant number 5, only that the suit is not defeated by absence of proper party. He is not a necessary party, but he has been impleaded because the roof of the first floor, it is a 2-story building. Initially, it was the ground floor and the first floor, which was been purchased by the Oshim Narayan Pandit. Oshim Narayan Pandit, during his lifetime, gifted the roof of the first floor to his one of his brother, Omyo Narayan Pandit, who made the construction thereon and resided there.
Roof is not a part of the hotspot.
No, it is not the part of the hotspot. Only thing is that I want to also protect the right of defendant number 5, Ochinto, so that he doesn't suffer subsequently in any frivolous proceedings. This sale deed, but this deed of gift was also been not
a co-owner in respect of the rest of the property.
No, he is not a co-owner because property was purchased by Oshim. That has been accepted in the written statement of defendant.
Exclusively Oshim's.
Exclusively Oshim.
The Omyo Narayan, who was his brother, Oshim's brother.
Omyo is Oshim's own brother.
So he was an unnecessary party. Why
he was unnecessary party. He was not
proper party.
Yes, he is not a proper party even. But he has been impleaded. He has filed an independent written statement which accepts the plaintiff.
Non-joinder does not entail dismissal.
Yes.
Non-joinder does.
Yes, my lord may kindly takes the. But this is the sum and substance of the plaintiff case and the pursuit for partition, which was only dismissed only on the one ground that Oshim Narayan purchase deed of Oshim Narayan Pandit could not be marked exhibit because it was not available. But the ownership of Oshim Narayan Pandit has never been denied.
by either of the defendant number 1 and 2 or defendant number 5.
You can file a collusive suit and have a partition between yourselves in that case.
But there is
proof of possession, title has to be there.
But if there is no denial of the fact, my lord, I will take it to lordship to the written statement. There is absolutely, categorically, unequivocally, plain case has been accepted, both in the written statement as well as in the evidence.
That written statement was filed by which of the defendants?
Defendant number 1 and 2, that is the other son Ashit Naran and Rajoshri.
3 and 4 have not contested.
3 and 4 are not contested. They have been served with the summons as well as the notice of appeal of the.
You are appealing for 1 and 2.
1 and 2.
You agree to him. You agree to the shares.
Yes, that is admitted. That's true.
Palpably collusive.
But difficulty is otherwise.
What is the otherwise? No material instruction.
No, your lordship.
No material instruction.
No, that is not difficult.
It can be otherwise difficult.
Well, in fact, I do not know that the plaintiff has succeeded.
So, what we are trying to cut short down. We will come back to you if necessary.
My lord.
What the time is. He has not expressed the entire property. None of the parties are in exclusive possession of something, part of the possession. Most
of joint property, partition is granted, then everything.
No, why? There are tenants, more particularly tenants inducted by my learned friend.
Maybe.
But if they are not evicted or something like that, my lord.
It not be evicted. Somebody gets a tenanted portion and royalty money will be adjusted. If I get a tenanted portion, then I have to be paid, compensated by money by the others.
Another thing is
that the final degree the commission will.
The two of the persons, namely Ashok Narayan Pandit and Narayan Pandit, they are in possession.
Yes.
Two brothers of Ashim Narayan Pandit, they are in physical possession of property by virtue of or permissive possession is there. Now that part,
only one brother is alive. That his son is alive.
No, yes.
All the
brothers was a brother. His son Ochinto is alive.
Ochinto is the son of Omiyo. He is in possession, and so far as
Ochinto means brother's son is alive.
Brother's son is
no other brother is alive.
No other brothers are alive.
Then how can they be in possession? Possession means
Ashok Narayan Pandit,
constructive possession as
and there yes. Ashok Narayan Pandit and Ananda Narayan Pandit, Omiyo Narayan Pandit, their heirs. Their heirs are in possession.
But this is the property is purchased solely by Ashim Narayan Pandit. He says that you have admitted that.
Yes, that's true. But Ashim Narayan Pandit allowed his two brothers to occupy certain portion of the property, and their heirs are also occupying that portion. There is no steps taken by the plaintiff.
But a partition suit need not be taken. That need not be taken. If a third party is in possession, whoever gets a share with the third parties gets his value adjusted by royalty money, and he has to take steps. In eviction suits, don't you find the landlord? There was a partition between the landlords, and a particular portion was allocated to someone, and he continues the eviction suit.
Subject to correction. If these two heirs of the pairs of Omiyo Narayan Pandit and Ashok Narayan Pandit, if they are not evicted or they are stripped of their possession, then how the partition will be affected? That is the
partition commissioner can answer you. We are not required to answer it. If we don't know that, partition commissioner will answer. That's not a good ground of this. Let us see the written statement.
Yes, my lord. If my
that is all your argument, then we'll look into the written.
My lord, kindly considers the plain case once.
Yes.
Plain case, my lord. I will place the relevant paragraphs only. Paragraph 3 at page 2.
Yes.
that it is by way of a year back in 1956, Oshim Narayan Pandit, son of late Abani Mohan Pandit, purchased all the land comprised in the sued property for valuable consideration for its erstwhile owner via a registered deed of conveyance, and a two-storied family dwelling house thereon started to reside with the members of the family of his family comprising wife Snehomoy, she died, two sons Apurva Oshit, and two daughters Rajashri and Joyashri.
But the foundational deed, if you don't produce anything, not even any photocopy.
Madam, may I just submit before Lordship?
Madam,
Order 12 Rule 6 says that there is no, Madam, even
Order 12 Rule 6 very well, but
Madam, even if there is no denial to the
entitlement, there is implicit declared. Your title is being declared in respect of a property. This is not an eviction.
But there is no denial. That it is not a fact that there is not the case even.
Persons will call you and come and say, "I'll file the suit." You will not deny. Then anything, my title can be declared in respect of anything.
But so far as the non-production of the title deed, purchase deed of the Oshim Narayan Pandit does not create a fetter in the suit for partition, if there had been any denial to that Oshim Narayan Pandit is not there, some other portion is there, some other brother of Oshim Narayan Pandit is there.
Suppose if there was no written statement filed, it was an expert degree, didn't you have to prove your title?
That would have been a very difficult position. If there would have been no written statement, but since there is a written statement and unequivocal to the plaintiff case, there is no issue at all. If I may permitted to place my order 15 Rule 1, there is no issue. There is before the court, there is no issue even. If the plaintiff case in toto been accepted by defendant number 1 and 2 and defendant number 5 independently, defendant number 5 is not comes under intestacy. But he independently filed a written statement since he had been impleaded, and he accepts the plaintiff case. But even if he would have not been made a party,
we will request you to try to find out any judgment which may be against you as to collusion. That a partition suit, in a partition suit, collusion is one of the relevant factors which is to be seen. If you don't find out, tell us.
My lord.
Just come back with that. We are tasking you against yourself, but we have full faith in your fairness. So we are requesting you as an officer of the court just to find out, to rule out our suspicion that in a partition suit, whether there is any element of collusion also has to be seen. Just go through, I mean, just search out. If you don't find it, fine.
I will try.
Because we don't have that. We have reserved so many judgments, we don't have the time to do that research. We are tasking you with it. If you find out anything against you also, we are confident you will bring that.
My lord.
If you don't find, tell us you have not found.
Definitely.
We will do our research later on after we conclude arguments. But now, for the present, we don't have time. So you please come back. We won't take up hearing next before Wednesday. And your matter has come up quite a bit because some of the matters we have heard already. Although the hearing is commenced, the matter cannot be heard today due to paucity of time. Accordingly, let the same be listed next on July 22, 2026. Now.